Let's discuss other federal securities regulation. In this video, we're going to discuss the Investment Advisor Act of 1940, the Securities Investor Protection Corporation or Protection Act of 1970, which is SIPC, and then the Telephone Consumer Protection Act of 1991. The Investment Advisors Act of 1940 defined what an investment advisor is, and they're firms that meet the ABC rule of investing. That means they give advice about securities, the A, that is their business, the B, and they're compensated for the advice they give, the C. There are some exemptions, though, to this federal law. So if you advise only institutions, insurance companies, banks, you don't have to register with the SEC as an investment advisor. Investment advisors that have less than 100 million of assets under management, they register with the states, not the SEC. Or if it's somebody that gives investment advice that's incidental as the course of their normal business, like a lawyer and an accountant. There isn't a whole lot of memory aids for this, but the one I want you to use is LATE or PLATE. Publishers, lawyers, accountants, teachers, and engineers. If you're a lawyer and the investment advice you're giving is incidental to your business, you don't have to register for investment as an investment advisor. Let's say it's a car accident settlement case. For example, let's say John Doe won a $100 million lawsuit in a car accident. That'd be very rare. But let's say it happened. 50 million for him, 50 million for the attorneys. Great. Well, now John Doe goes, well, I just came into 50 million bucks. What do you think I should do with it? The attorney goes, oh, well, I know this guy Colin Kleck over at PFS Investments, real credible guy. I can give him your contact info. Maybe you should consider buying a mutual fund. Well, guess what? The attorney just gave investment advice, but it was incidental to his practice. So if you're a lawyer, an accountant, a teacher, or an engineer, and the investment advice you give is incidental, then you do not need to register as an investment advisor under the Investment Company Act of 1940. The Securities Investor Protection Act of 1970 protects customers in the event that their broker-dealer goes bankrupt. This is usually associated with street-named accounts, those accounts that are first held in the name of our broker-dealer with further credit to us. According to SIPC, the maximum coverage is no more than $500,000. $500,000 in securities is the max. However, they further limit the amount that can be covered in cash. So the maximum coverage for SIPC is $500,000 total, of which no more than $250,000 can be covered in cash. The $250,000 limit is there for the cash coverage amount, so that our SIPC protection under our broker-dealer keeps up with FDIC coverage at the bank. So FDIC coverage for cash claims is $250,000, so SIPC builds that in. So you assume, always, that the cash portion will be taken out first by the investor if the broker-dealer goes bankrupt. Anything above the covered amount, so if you've got, let's say, $800,000 with your broker-dealer and the broker-dealer goes bankrupt, the other $300,000 that you've not been able to claim and get back, you now as the customer become a general creditor of your broker-dealer. The Telephone Consumer Protection Act of 1991 governs all cold calling, and it stipulates that you can only cold call a customer or a potential customer between 8 a.m. and 9 p.m. in their local time zone. We must disclose our name, the firm, the location that we're at or calling from, and our telephone number to reach us at, and the purpose of our call. So what if a customer asks for you not to ever call them again, you put them on a do not call list? And customers on a do not call list, these do not call list items apply to phone calls, faxes, and U.S. mail. Under the Telephone Consumer Protection Act, a company must honor a customer's request to not call them on the do not call list for 5 years. This is separate from the Federal Trade Commission, which is a national database registry that the name of the do not call list will be held indefinitely. Also, I want you to remember that customer complaints must be retained for 4 years, and this is a FINRA rule. That's it. In this session, I've talked about the Investment Advisor Act and some of its exclusions. We've looked at SIPC under the Securities Investor Protection Act, and we've also took a look at the Telephone Consumer Protection Act that was passed in 1991. This concludes our session. It's time now that we've wrapped up the video to you go over to millionairesintraining.com and take some of our practice exam simulators. Focus on doing the ones that you're not scoring high enough in certain areas. You can gauge this by looking at taking our final exams and seeing what area you didn't score as well in. Look for answer choices that you missed and reread the explanation. Take exams multiple times in order to benefit and get better scores. I'm Colin Kleck, and I'll see you in the next video.